let me bring this up to February of 2022. In the last 24, 48 hours. So a couple of interesting things have happened, right? First of all, we've discovered, or public has discovered, that there are members of the Canadian Armed Forces who have evidently been somehow involved or supporting these trucker convoys slash occupations, whatever you want to call them, on the one hand. And on the other hand, we now have the imposition of the Emergencies Act. Preston, you talked about the idea that civilians evidently can be tried within the context of the military justice system, but we don't do it or can't do it as it's currently constituted in the context of the Canadian system. Maybe I misunderstood that. But in any case, what happens to these folks? So let's say that some of these folks are found to have been actively supporting these protests. And there's evidence that they have been actively providing whatever, either material support or operational planning support, or logistics planning, or whatever the case may be. What happens to those folks? And does the imposition of the Emergencies Act change what could potentially happen to them going forward? It seems to be a rather complex joining together of different things happening simultaneously. Maybe I don't even know what I'm talking about, but I just sense that this could be a complicating factor somehow. So whoever wants to take that, please feel free.
I'll jump in, Dan, if Preston doesn't mind. That's a polycentric question. That's an incredibly polycentric question. So I'm going to start with some comments based upon some of the things that I've seen on social media, because there's some misconceptions, some significant misconceptions out there. So first off, with invoking the Emergencies Act, and specifically it's under Part 2 of the Act, which deals with a public order emergency, that does not create martial law. Okay, so people comment about how, oh, now it's martial law. That is fundamentally not martial law. So martial law is often defined as typically the temporary substitution of military authority over civil authority. That's not the case. So the military remains in Canada subordinate to civilian control. This is not martial law. More importantly, invoking the Emergencies Act does not automatically engage the Canadian forces, right? It does a variety of things, but it doesn't automatically engage the Canadian forces. And the reason people might think that is because the last time that similar legislation, the War Measures Act, was invoked in 1970, the military was also called out under aid of civil power under the National Defense Act. So you've actually got two separate federal statutes that are relevant. The third comment that I'm going to make before I get into a couple of more detailed points, Dan, is people say, well, this is the end of democracy. Well, no, it's not the end of democracy. Because first, the Emergencies Act is valid legislation that was passed by Parliament, right? So the executive, the government, is relying upon lawfully enacted legislation that was enacted by a lawfully elected Parliament. Secondly, the Emergencies Act has very robust supervisory role for Parliament. So a motion relating to the emergency must be tabled before Parliament within 7 sitting days, and Parliament is sitting presently. So it has to be tabled within 7 sitting days, which will be next Monday, for Parliament to vote on, and Parliament can revoke the invocation of the Emergencies Act, right? That is the parliamentary supervision under Part 6 of the Act. So when people say it's martial law, they're wrong. When they say this is the death of democracy, they are wrong, right? It's not even open to debate. That's not the death of democracy. Nor does it include necessarily involving the armed forces in any way, shape, or form in the enforcement of any public order emergency. Okay, so that's the initial comments that I want to offer. With respect to your specific questions about members of the armed forces who may be involved, it's a polycentric question because it depends on the nature of their involvement. Suffice to say, certain things are relatively clearly a contravention of the Code of Service Discipline or a contravention of a directive, regulation, or order for the governance of the Canadian Forces, which would lead to potentially a Code of Service Discipline offense. So the first thing I'm going to say is, I don't presume that anybody's guilty. In fact, I'm a defense counsel. I start with the presumption of innocence. Okay, but if somebody may have contravened the Code of Service Discipline, and I'll give you an example. I won't speak to any specific case, but it's something that's going to be foremost in a lot of people's minds. There have been some videos made by members of the Canadian Forces while in uniform talking about controversial public policy issues. There is a QRNO provision, QRNO Article 19.36, specifically paragraph 19.36 sub J, that prohibits a member of the Canadian Forces from publishing, giving a lecture, or otherwise broadcasting commentary about public policy of a controversial nature. That prohibition is a valid expression of law. It's a ministerial directive. Contravening that prohibition is a potential Code of Service Discipline offense, at the very least, under Section 129 of the National Defence Act. A charge could be laid based upon a validly conducted investigation that gathers sufficient evidence to support such a charge. And I'm not presuming that that has necessarily been done. What I would suggest is, if an investigation is conducted, a disciplinary investigation is conducted into a matter such as that, it is important that that investigation be conducted efficiently and not take several months, because there's probably little justification for taking that long. And if there is sufficient evidence to support the laying of charges, I would suggest that it is a more appropriate course of action for the Canadian Forces to proceed under the Code of Service Discipline than to attempt to proceed under administrative measures. And there's three reasons why. The first reason is, if you proceed under the Code of Service Discipline, it is transparent, it is public. If you proceed administratively, you're dealing with personal information, it is not transparent, it is not public. When the alleged wrongdoing is very transparent and very public, it requires a similar response. Second, the Code of Service Discipline has robust protections for an individual accused of such wrongdoing, including potentially trial before the independent judges that we've been talking about this evening. The accused would benefit from representation by defense counsel, as well as a robust prosecution by the Director of Military Prosecutions. And the third reason is, if the chain of command perceives such alleged misconduct as being very serious misconduct, it warrants being dealt with under the Code of Service Discipline to use the appropriate tool for the maintenance of discipline, efficiency, and morale, which we know from Genereux and we know from Stillman, in a manner that reflects the seriousness of the alleged offense. If they proceed administratively to deal with these matters, I would suggest they would undermine the credibility of the Code of Service Discipline.
Okay, so just to help me understand this a bit further, so let's say, for example, that some of the folks, it's unlikely, but some of the civilians who have been involved in these various protests, you know, if the civilian, if there was a decision to charge these people with something very serious, I don't even know if in Canada we have something like sedition, but let's say something like that. And those people were charged with that. I'm trying to get this concept in my head in terms of punishments and equal punishments. You know, if somebody who was involved, who was a military member and was supporting the same activity, would they be subject to the same sort of punishments that a person who's a civilian, who's perhaps charged and convicted of those kinds of serious crimes? I mean, is there any possibility that you'd end up with two different outcomes because one is charged by the civilian courts and one is charged by the military system?
So I can start by kind of briefly addressing the question, then I'll turn it over to you, Rory. But there are sentencing principles that judges have to take into account when they are sentencing people who have been convicted. And they differ in the military context when you compare that to the civilian context. So for example, I'm not going to list them all, but some of the general principles that civilian justices have to take into account: deterrence, denunciation, rehabilitation. In the military context, a lot of those principles are the same. That's true. But there's the added caveat that there are specific military sentencing principles that military judges have to consider, such as the good order, for example, of the Canadian Armed Forces operational effectiveness, things like this. And so it is possible that depending on how you shunted a case into one of the two systems, you would get a slightly different, at least, sentence between the two.
So to carry on, Dan, from what Preston said, so yes, we do have an offense of sedition for civilians under the criminal code. It's section 59. You will not see it charged very frequently, right? Because sedition requires advocacy for change of government by force of arms. And we're not just talking about some crackpot putting up a video. We're talking about a deliberate effort to try and change government by force of arms. There's an equivalent offense under the Code of Service Discipline at section 82 of the National Defense Act. So even though, as Preston explained with respect to Stillman, paragraph 130 sub 1 sub A of the National Defense Act allows us to incorporate in the Code of Service Discipline criminal offenses like sedition under section 59. The Code of Service Discipline has its own version of sedition under section 82. If that were warranted, and I haven't seen evidence that it is yet, but if it were warranted, it would be charged under section 82. So you've got two different offenses, because a member of the armed forces who's prosecuted under the Code of Service Discipline would be prosecuted under section 82, whereas a civilian would be prosecuted before a civil court of criminal jurisdiction under section 59 of the criminal code. And because we are not in martial law, civilians would not be tried under the Code of Service Discipline. In the case that Preston had mentioned, arising in the United Kingdom with Martin, the reason why a civilian, essentially a dependent of a member of the British Armed Forces, was tried by court-martial was because that dependent was resident in Germany at the time, because his father was a member of the British Armed Forces. And under the Status of Forces Agreement, the United Kingdom could maintain disciplinary jurisdiction over that basically a minor. Because I believe, if I'm not mistaken, Preston, he was a minor child too, wasn't he? He was 17.
Right.
Yeah. So, and in fact, the alternative to being tried by court-martial would have been tried by the German authorities, right? Which, frankly, I think it was better that he was tried by his own country.
Yeah.
But since we're not in martial law, no civilian would be tried by court-martial. So is there a possibility that you get two different sentences? Absolutely. But again, as Preston mentioned, both courts-martial and civilian courts of criminal jurisdiction have very similar sentencing principles. What changes, and the basis for why the punishment might be different, is the context, and most specifically, the context of the offender. So if you have a civilian convicted of sedition before a civilian court, and a member of the armed forces convicted under section 82 by court-martial, you're dealing with something that is arguably, objectively more serious, because it's one thing when a civilian calls for the change of government by force of arms. It's quite something else if a member of the armed forces who's there to protect the country is doing the same thing. So it's not a flaw in the system. It is an acknowledgement of the complexity and the versatility of both the civilian criminal justice system as well as the court-martial process.
I just brought that up because I think these are questions that are swirling around in the news. They're swirling around in people's minds, and we're trying to make sense of all these things, because these are, for most people in Canada, these are not issues that we've had to deal with anytime recently, for sure.
This has been another in our series of webcasts produced by the Royal Canadian Military Institute in Toronto as a public educational service. You can find news of upcoming events and links to our webcast archives at www.rcmi.org. On behalf of the RCMI, this is Eric Morse saying goodbye for now, and thank you for joining us.